Bernadine Adkins is a partner on our antitrust team. She's going to lead us through the changes in the UK competition law, recognising the challenge of compliance in antitrust law for companies large or small. Bernadine, with the introduction of the Enterprise and Regulatory Reform Act 2013, significant changes have been introduced. What are the highlights from an in-house law's perspective?
The main change is that as from April the 1st of this year is that the Office of Fair Trading and the Competition Commission have been replaced by a single competition authority called the Competition and Markets Authority. Now this means that this is going to be the principal agency for enforcement of the competition rules, with responsibility, for example, for all merger reviews and also for market study investigations. But the same token, we can expect to see also more enforcement activity from the concurrent sector regulators such as Ofgem and Ofcom, as the Secretary of State basically has powers to remove their enforcement powers on the basis that so either they use it or they lose it.
So apart from a single authority for transactions, what else has changed in merger control?
The CMA is going to have increased powers to suspend or reverse integration of completed and also with respect to anticipated mergers. And also if a party doesn't respect these so-called hold separate requirements, they can be very heavily fined, up to 5% of their worldwide turnover. Also, we are seeing a much more rigid approach, more like perhaps the European Commission, insofar as there's now a set form. We have a statutory time period of 40 working days. In practice, what is this is meaning is that now you have to engage in more pre-notification discussions with the CMA. The duties of data disclosure to the CMA are also much more onerous. Much higher burden on parties, and also parties are required to sign a statement of truth with respect to the data they are putting forward to the CMA.
So changes in the Enterprise Act 2002 has introduced criminalisation of individuals engaged in cartels. What can you tell me about that?
Well, essentially what has happened, there simply has not been sufficient, as people anticipated, enforcement activity with respect to individuals who've engaged in cartels, in other words, competitor-to-competitor arrangements such as price fixing or bid rigging or market sharing. So what they've done is to remove the mens rea, the dishonest requirement, and what they've put in place are certain defences, such as that the person in question made reasonable attempts to consult a lawyer with respect to the arrangement, or that they had no intent to hide the information relating to the agreement from the customer in question. So we expect to see, as a result of this, much more action in terms of prosecutions of individuals for a criminal offence, and possibly more people under the spectre of a jail sentence.
There's been an increase in the use of antitrust law in litigation. Any highlights there?
Yes, it's a very lively scene at the moment, and I think probably a permanent landscape now of competition law. More pressure is being put on some in-house lawyers as commerce is looking to them to become a profit-making aspect of a company. Judges are getting more impatient with the cases that we do have ongoing, because a lot of these cases are not progressing. So we're seeing more case management conferences where the judges are pressing the parties to progress these cases. Looking forward, we now have the about to be adopted the EU Damages Directive, which is supposed to make things easier for claimants to claim damages, both in the UK and throughout Europe. We're also seeing the Consumers' Rights Bill, whereby we are going to see collective actions on the rise.
The CMA have been talking a lot about their investigation into Mercedes-Benz. What is the message for an in-house lawyer coming out of those decisions?
I think two prime messages. Yet again, the competition authorities are saying that where somebody is in a central position with respect to other parties, such as a manufacturer with respect to their supply network, their distribution network, they are under an enhanced obligation to ensure that any collective action between those dealers does not tip over into an infringement of the competition rules. And the second aspect that I think is very useful for in-house lawyers to be aware of is this notion of publicly distancing oneself from where you come across inadvertently an illegal arrangement, such as inadvertently some information can be sent to a company by mistake or deliberately sometimes, and in those circumstances, rather than having to do a leniency application, you're better off simply publicly distancing the company from that particular arrangement in question.
What are the principal risks for in-house lawyers in this rapidly evolving landscape?
I think the risk lies with the asymmetry of information between this landscape that is changing so much, and often the devil is in the detail here. Sometimes the system looks rather much the same, but as with mergers, there have been radical changes, but the word isn't always out there, and it's only until somebody's actually engaged in one of these merger situations, for example, that the true import of these changes takes place. So I think in-house lawyers need to be careful not to assume that what happened in the past is going to happen in the future, and to inform themselves about these rules so that they are in a position to appropriately risk assess as to what's the needs, the extent to which there is a need for changes to compliance programmes and enhanced education of their staff.
That's been a really useful overview of the changes in UK antitrust law. Thank you, Bernadine.
Pleasure.